were requested informally to just not go there so that we wouldn't disrupt the federal process, which went from investigation to prosecution. And then finally, I think it's very important for everyone to recognize that my job is to just, to assert the state's case as best as we can, or the people's case as best as we can. And I have to be mindful of potential prejudice, and we have to safeguard Mr. Matar's rights. And the motive evidence here could potentially give rise to prejudicial, prejudice of potential jurors and so forth. So looking at everything, we made a decision conscientiously not to present motive evidence, and we felt, and I think the end result justifies our opinion that we could prove intent without getting into motive evidence. So we have done so. I don't like the fact that it was thrown back in my face, especially in light of the fact that the defense at one time had filed a motion trying to preclude me from going in that direction. But at the same time, and I think it's important to recognize that the defense itself also had a very difficult time at dealing with this fact pattern and the surrounding circumstances and the dynamics in their defense, and their vigorous defense, which I thought was a very good defense. And I think Mr. Barone does a very effective job in what he does, and I wouldn't take anything from him because I think that that's a very difficult job. I think each one of us had very difficult jobs, different roles and responsibilities in this process. So I just wanted to address that. I think the only thing I would say to you is that, and I think I've said this before, 3 years is a long time. It's been a lot. There's been many delays from my perspective. I'm just glad that justice delayed is not justice denied. Mr. Matar had came into, New York State as a visitor. He's now a resident, and, he has 25 years plus whatever credits he has already received for the time, that he has been incarcerated since this event. We're closing in on 3 years shortly. He will receive credits for good time, for there's all kinds of opportunities that are available in the state corrections system that might mitigate the sentence, administratively outside of the courtroom. And I hope that he utilizes that time because, I recognize at my age that when he gets out, he'll be younger than I am now. And he'll have a fairly full life ahead of him, and hopefully he'll reconsider, his value system in light of what's occurred here. It's a tragedy. It's a tragedy that anyone should resort to this level of violence. It's a tragedy that all of this occurred. It's a horrific event that despite what Mr. Barone argued in the courtroom, which I think was very effective, and I think it was a good argument. Mr. Matar controlled all of this, including the selection, not just of the venue and the subject matter that was occurring at that time, but of his intended target. And all of that swings both ways. So unfortunately, again, while it's difficult for us, certainly it was difficult for Mr. Barone and his group, and I think they did a good job, and I want to acknowledge that. The only other thing I want to say to you is that, I want to acknowledge Mr. Rushdie and Mr. Reese. They have both undergone, a traumatic event in their lives. And I do want to acknowledge those people on the stage, both employees of the institution and just visitors who rushed to the stage at their own peril and, considerable personal safety risks to stop this attack before the completion of the act, and to save Mr. Rushdie's life. But for their interaction, I think the evidence is clear that Mr. Rushdie would have bled out from about 15 holes that were inflicted upon his torso and his neck and his face right there on the stage in front of everyone who was there to watch it. And I would say something else, and I said it in the courtroom. I had asked the judge rhetorically to consider, in his 50-some-odd years of life, any horrific events he's witnessed, and I ask each and every one of you to consider that too. I can look back on seemingly innocent. I recall, watching a car accident, watching certain things that stay with me 50 years later, and I am certain in my mind that those individuals that were present when this occurred and witnessed it are impacted by this. And yes, I did refer to them as victims because They didn't ask for this, and they will live with this for the rest of their lives. And those that were closer to the stage will probably have a much harder time than those that were seated in the back. Those that actually were on the stage or came out upon the stage, including some very brave individuals, they're going to have to deal with this for the rest of their lives. So this sentence does hopefully take into account them as well, and hopefully they can start the healing process along with Mr. Rushdie and Mr. Reese. And with that,
procedural question, if you might. On a determining sentence, it's been a little while for me. Not that I've had one, but on a determining sentence in New York State, can you still get out after 6 7s? Is that still the case?
Essentially, yes. There are all types of credits available in the system. We should note that the system limits the availability of credits that might be taken advantage of by an incarcerated individual when that person has been convicted of a violent felony act rather than a non-violent act such as drugs or something else.
But the 6 7s is still in existence?
Essentially, yes.
Okay.
What do you think about Mr. Matar's speech at the end? And I didn't hear him say, "I'm sorry," or "I regret what he did." What do you think about that?
Yeah, I think he was trying to thread a needle that was, because in his speech, he, in effect, was providing the motive evidence that that his counsel was saying was lacking here. And I understand why Mr. Barone asserted that. And I think that was, good for him for saying that. He was doing his job very well. What more can I say? There's an irony to all of this, right? I mean, his value system is that he can impose his own sense of justice and sentencing upon somebody who violates, his value system, and that was problematic.
The case, as you said, has been going on for a long time. Does the sentencing sort of bring a sense of closure, not only to the victims of the case, but to you guys as well, and why?
Sure. There are post-conviction remedies that are available to this defense counsel, and they've indicated that they intend to aggressively pursue those. And so, although we move into a different stage, it's quite a different situation for us. As I've lamented about so many times, we have some very difficult hurdles to overcome because we simply don't have the assets or the resources to do our jobs easily in compliance with New York State's discovery laws, which were dramatically changed a few years back. And unfortunately, they have overshadowed this case. So now that we've gotten to this point, the two areas that I was most concerned about getting in through the trial is potential prejudice opportunities that might derail us again. And then certainly discovery compliance, which is always just a very difficult thing for a small prosecutorial office.
Did you wish to have, or did you ever talk about Mr. Rushdie's letter being read into the record as a victim impact statement?
Well,
thoughts on why it wasn't?
Well, when you say read into the record, it is part of the record. The record will include whatever's stated in the courtroom and also any written submissions that are filed in connection with the action. So Mr. Rushdie's statement is included in the pre-sentence investigation report. But why didn't I? I'm sorry?
But that's not part of the public record, right?
Well, it's not part of the public record because by statute, the pre-sentence investigation report is a sealed document.
Right.
However, it is part of the record of this proceeding, which will travel with Mr. Matar as he goes into the system. Now, I could have read into the record, yeah. And I thought about it, and I actually didn't anticipate the lengthy conversation, which I thought was a good conversation, a healthy conversation between Mr. Barone and Judge Foley. I was trying to get past some of the more obvious and self-evident points. Obviously we have two individuals that are in their mid to late 70s who were stabbed. Mr. Rushdie was stabbed about 15 times, and Mr. Reese was injured himself. So I could have gotten into Mr. Rushdie's letter as he described the trauma, that he has undergone. I would say that essentially most of what he conveyed was reflected in his courtroom testimony, but in the courtroom testimony he was obviously precluded because it's irrelevant from getting into the post-traumatic stress that he has endured since then.